section on your business with accent nominees. So last week we did an introduction on what we'll be looking at for the next couple of weeks, which is your business and the law. So if you are just joining us on this series, I would encourage you to check out our previous series on what next after business registration. We had a lot of things to talk about, so you can just check our previous videos on this same channel, Accent Nominees, on Facebook, and also at Law Accent on YouTube. So we have a lot of videos where we discussed what next, what you need to do after registering your business. So this is a new series, and this is like our first official conversation, because last week we just did what we did was just to do an overview of what we'll be looking at, what we'll be talking about under this series. So today, to start, we'll be looking at your business and the law of contract. So we'll be just talking about the law of contract and what you need to know. So basically, and in simple terms, when you say contract, it basically means an agreement or an understanding, either written or oral. So it can be in written form or it can be in oral form, but as long as it is an agreement between parties, mutual agreement, so it's not like someone is forcing someone to sign something, or someone is forcing someone to say something. So a contract is a mutual agreement, understanding between two or more people. So you can have 3 people, 4 people, 5 people enter into a contract. So you cannot just have yourself alone. You can't have a contract with just a single person. So you need at least 2 people to form a contractual obligation or a contractual agreement. So a contract is an agreement between 2 or more people, a mutual understanding between 2 or more people to agree to do something, to do a thing, or to carry out a particular task, and with the understanding that where there is a default or where someone fails to perform his or her own part of the contract, then the other party can seek redress in a law court or under arbitration, or can just seek to enforce the contract or have parties come together to discuss the way forward. So when we talk about contracts, there's always this in law we call it intention to create legal relations. So there's always this intention that this contract I'm entering into, this relationship I'm entering into, is going to bind me and also going to bind the other party. And where there is a failure, where there is a default, where there is a refusal to do something, the other party is aggrieved. So what you'll be doing to that person, like you're going to cause like grievance and all of that. So there's going to be like a damage. So the other party can ask for damages or compensation for non-performance of what you've agreed to do. So going to what we'll be talking about today, talking about your business and law of contract. So with the understanding that contract is an agreement, either written or oral, between parties to carry out a particular obligation, and with the intention that where there's a default, then the other party is going to be entitled to some sort of compensation. So over time, people enter into contractual obligations, and it's something that we even see day to day. Like, it's an arrangement that happens every day. This is just 2020 now, and you can't imagine the number of contracts that has been executed, signed by people today, and that's just today. So contract is something people do every day. And when you say contract, sometimes you might just want to avert your mind to, oh, maybe you award, like someone is being given a project to execute. So it's not just limited to that. So let's say you want to engage the service of someone to carry out a particular obligation, or to do something, to render service, or to supply some goods for your business. It is a contract. So even when it is not written down, as long as there is an understanding, because so we'll be looking at some elements, like what can you say a contract exists between 2 parties. So under the law of contracts, we have terms like offers, we have terms like acceptance, we have terms like consideration, we have terms like intention to create legal relations. So when you say offer, when you talk about offer, so this is someone like offering, just like as the word implies, someone is offering to do something, either to sell something or to provide a service. So that is the offer. And it can also be another way around. You can, the person receiving the service might be the one making the offer too. So it depends on who the offer is coming for, but there's always an offer, and then it is followed by an acceptance. So I can say I'm selling shoe, and you say you want to buy my shoe, and I tell you I'm not selling. So you can't say there's a contract between us because I've not accepted your offer to buy shoe. So under the law of contract, so we have what is called invitation to treat. So if I put my goods on display in my, let's say in my supermarket, I have a supermarket and my goods are there on display, it is just an invitation to treat. I'm inviting you, okay, you can check this out. So if you now pick the, let's say you pick a particular pair of shoe in my supermarket and for this particular item. So if I pick a pair of shoe in my boutique, and or you pick a pair of shoe in my boutique and you say you want to buy it, and I tell you I'm not selling, you can't sue me under the law of contract to say I failed to sell that shoe too, because I'm not the one offering it to you. You are the one making the offer now to buy the shoe, because what I've just, making the offer now that I should sell it to you. Then if I now accept, acceptance is me now saying okay, yes, I'll sell it to you at this particular amount. So that's where consideration comes into play. So consideration is always in money or money's worth. So create legal relation. So at the time of making that offer and accepting it and giving me money, so there's this intention, like there's an implied intention that okay, after receiving money, you've told me you need this pair of shoe. Okay, I tell you I'm going to sell it for you at this particular amount, let's say 10,000. I agree to sell it at 10,000. Now you've credited my account with a token of 10,000. Consideration is made, then a valid contract is already in place. So once that is done, then you as well agree with me that if after receiving money, after receiving the sum of 10,000 naira, I now fail to deliver the shoe to you, then that's where you can talk about, oh, there's a breach of contract. So I believe we can easily relate with what contract is about now. So it can be for provision of service. You can engage a lawyer and you furnish consideration, and let's say the person refuses to perform the particular obligation or service, so you can file an action for breach of contract. Or if it's you subscribe to a particular service for someone to do something for you and person failed to do so. When you talk about contract, so it is not just limited to services, it is not limited to goods, it is not limited to products. So as long as there is an understanding and there's these elements, offer, acceptance, consideration, then there's an intention to create legal relations. So it is not a conversation, oh, so let's just paint this scenario. I approach you and we're just having a conversation, and it's just a normal conversation, and there's no intention that I'm going to be binded by what we've discussed. So let's just say we're just talking as friends, and I'm just trying to recommend some things to you. Then based on what I've recommended and you rely on it. So there are different, it depends on the scenario though. You can rely on something. I can recommend something to you and you rely on it and you'll be liable if at the end of the day my actions, like I relied on what you told me, and at the end of the day it's discovered that what you said is actually not true. So sometimes some honest opinion too can make you liable. So it depends on the scenario. But generally, if there's no intention to create legal relations, let's say we are just having conversation, you can't bind me. But if there is an intention to, you know that if this person should rely on this thing, these are the consequences, and also it is always good you are very much aware of what the information you give out to people out there or what you agree to do. So before now, people have been entering into contracts, like I said, at this time you wouldn't want to imagine the volume of contractual obligations or contractual agreements that people have entered into today. So before now, people have been entering into contracts, and during the course of this conversation, if you are very much deliberate, you can even cast your mind back to several contractual obligations or agreements that you've had with people that are not documented. And at the end of the day, if you are very unfortunate, you might have one or two cases where someone has agreed to do something, and you've, let's say, paid or mobilized that person to do that, and at the end of the day the person failed to do what he or she said is going to do. So you can easily relate with it when you say there is a breach of contract, and when what you think is a breach of contract is actually not a breach of contract, because there's actually no contract in the first place. So before before the 21st century, people have been entering into contractual obligations, and they were purely like majorly oral. But it was discovered that there was a lot of cases of people saying, I will do this, and